May it please the court, I'm Emily Zoe, and alongside my co-counsel Louisa Valentine, we represent the respondent, the University of North Carolina, in the case of the Students for Fair Admission versus the University of North Carolina.
Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
No. When the 14th Amendment was passed, it was not intended to mandate race neutrality, and in fact, there were a variety of programs that followed closely that actually mandated race consciousness as a way to ameliorate the impacts on Black Americans that slavery as well as other racial discrimination had. And so when the 14th Amendment was passed and interpreted, it created three separate distinctions for the types of classification and discrimination that are and are not allowed under the 14th Amendment. Race or discrimination and classification on race is put under strict scrutiny, meaning that the government must prove that their law is both narrowly tailored and has compelling state interest in order to remain constitutional. And race-conscious affirmative action abides by both of these prongs. Moreover, as additional evidence that the 14th Amendment was not intended to mandate race neutrality, like I mentioned before, there were a lot of programs that were race-conscious as a way to ameliorate the impacts that slavery had. And while some people may argue that these laws and programs were passed exclusively based on the recipient's statuses as former enslaved people, many of these laws did not differentiate between formerly enslaved people and other Black Americans, meaning that the expressed intent of the Reconstruction Congress was simply to amend the harms of systemic racism caused by slavery and not only the actual physical harms that slavery had on formerly enslaved people. Representative Moulton explained that race-conscious measures adopted during Reconstruction were intended to break down discrimination between whites and Blacks and ameliorate the condition of the colored people in 1866. At the time of the passing of the 14th Amendment, it was understood that slavery was synonymous with being Black because an overwhelming majority of Black Americans had been enslaved and were impacted by slavery. And even those that hadn't actually been enslaved themselves, it was understood by Reconstruction Congress that they still had to deal with the negative repercussions and impacts of slavery, including racial discrimination, segregation, Black codes, Jim Crow laws, etc. Additionally, in 1971, in Swan v. Charlotte Mecklenburg Board of Education, the Supreme Court upheld the race-conscious busing of students to promote integration in public schools, once again showing a program that was race-conscious and abided by the 14th Amendment as well as the original telos of the 14th Amendment.
How does the legislation enacted by Congress in the 1860s and 1870s affect your answer to question number 1?
To elaborate on my last answer, the 39th Congress approved race-conscious programs designed to enable Blacks to improve their situation, both economically and politically. And although these programs were originally intended to remedy the institution of slavery, there was, again, no attempt to screen individual Black participants to assure that they were actual victims of slavery or to measure the degree of past disadvantage, again showing that the aim of the 14th Amendment was simply to create a more racially equitable society and not exclusively to ameliorate the impacts that that slavery had on formerly enslaved people. Additionally, Congress passed the Freedmen's Bureau Acts of 1865 and 1866, which provided food, shelter, clothing, medical services, and land to newly freed African Americans, another example of a program that did not differentiate between formerly enslaved people and other Black Americans.
Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
Yes. It is important to understand that the vision of the Congress is to attempt to correct racial inequality in an inherently and systematic racist society. Republican Representative Thaddeus Stevens from Pennsylvania, who served in the House of Representatives from 1859 to 1868, stated that the 14th Amendment allows Congress to correct the unjust legislation of the states, so far that the law which operates upon one man shall operate equally upon all. The injustice is referring to the Three-Fifths Compromise, slavery, Plessy v. Ferguson, Dred Scott v. Stanford, and other laws which were explicitly discriminatory toward racial minorities. But this vision for the 14th Amendment still prevails for the racial equality that it strives is still unmatched. The 6-year graduation rate for first-time full-time undergraduate students who began their pursuit of a bachelor's degree at a 4-year degree granting institution in the fall of 2010 was 64% for white students, 60% for students of 2 or more races, 54% for Hispanic students, 51% for Pacific Islander students, 40% for Black students, and 39% for American Indian, Alaskan, Native American students. And this is from the National Center for Educational Statistics. Furthermore, it is still very important to highlight that having a racially diverse campus is still a compelling state interest for universities, regardless of how societies may look like now, and regardless of whether or not systemic racism is still a societal problem. And since race-conscious affirmative action supports racially diverse campus bodies, and since, as we argued in our brief, the policy is narrowly tailored, then race-conscious affirmative action should still be held to be constitutional.
Let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
Yes. Systemic racism works against all racial minorities. The unique problem of slavery needed the unique solution of race-conscious affirmative action. However, it is needed to understand that all racial minorities also have unique problems that also require the unique solution of race-conscious affirmative action. Asian Americans have dealt with the Chinese Exclusion Act, internment of Japanese Americans during World War II, and in 1854, in the case of People v. Hall, which determined that Chinese people could not testify against white defendants. These are all very unique problems. Hispanic Americans have dealt with lynchings and segregations in schools, much like Black Americans. And Native Americans have dealt with Carlisle schools, which attempted to assimilate Native American students into white culture and had very inhumane practices. And so therefore the graduation rate, and as mentioned, the graduation rates for people of color are just as low, if not lower, than of African Americans. In order to realize that the original intention and telos of the 14th Amendment, race-conscious affirmative action should be extended to other races as well.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
It's important to understand that the writers and framers of the 14th Amendment, their intention was to unleash a vision of equality that has gone on and followed the logic of their own momentum. And these people are legacies of that momentum. When the 14th Amendment was created, it was intended to create a more racially equal society in America. And it's important to understand that that original intention still follows through into our ever-changing society, and that the writers and framers of the 14th Amendment understood that equality would shift to mean different things as our society shifted and moved into different things. The framers wanted future Congresses to morph the 14th Amendment and utilize the 14th Amendment to further equality regardless of what society demographically looks like, because they understood that America's demographics and populations were ever changing. These framers were choosing to set a sail for the future of societal equality using the 14th Amendment rather than anchor us in that time period, since our demographics are much different and the way that people identify is much different. And so therefore I think that the framers of the 14th Amendment would have agreed with affirmative action benefiting people on the basis of sexual orientation or gender identity under the 14th Amendment, especially since that is one of the classes that is protected under the 14th Amendment. However, I'd like to remind the court and the judge that the case at hand refers exclusively to race-conscious affirmative action, and that neither side is advocating for or against affirmative action policies that benefit people on the basis of sexual orientation or gender identity.
Does Brown v. Board of Education 1954 prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
Quite the contrary. Race-conscious affirmative action prevents segregation. Thus, it honors the ruling that segregation should be avoided in order to hinder social racial hierarchies as established in the case of Brown v. Board of Education of Topeka. Hypotheticals are not needed to conclude that race-conscious affirmative action prevents segregation and bolsters racial diversity. The laboratories of democracy have witnessed what happens when affirmative action is eliminated. In 1996, the state of California approved Proposition 209, which provided the consideration of race, ethnicities, and in the admissions process, which prohibited the consideration of race, sex, or ethnicity in the admission process of public education. Alongside with California, the states of Texas, Louisiana, and Mississippi also upheld bans on race-conscious affirmative action after the 1996 Hopwood v. Texas decision. Proposition 209 had an immediate effect on the state's elite universities in California. Black and Hispanic enrollment at Berkeley and Los Angeles flagship campuses has dropped precipitously. Legal challenges to the policy were unsuccessful. According to a study published by the University of California, Prop 209 caused a decline in system-wide URG, underrepresented groups, enrollment by at least 12%. The decline of students of color caused by Prop 209 and 1996 Hopwood v. Texas decision can also be traced in medical schools. A study published in 2016 revealed that affirmative action bans have led to about a 17% decline from 18.5% to 15.3% in the first-time matriculation of medical school students who are underrepresented students of color. Following Brown in 1971, in Swan v. Charlotte-Mecklenville Board of Education, the Supreme Court upheld the race-conscious busing of students to promote integration in public schools in order to remain consistent with the decision in Brown.
It's also important to note that in Grutter v. Bollinger, it was actually explicitly mentioned that race-conscious affirmative action, like my co-counsel has explained, was intended to improve the racial diversity in consistency with Brown v. Board of Education on college campuses, and therefore Brown v. Board of Education actually furthers the need for race-conscious affirmative action.
In 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. When will there ever be a point in which time racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
The compelling state interest of racial diversity is timeless, so yes. In Grutter v. Bollinger, the court states that the law school's goals of attaining a critical mass of underrepresented minority students is not an interest in merely assuring within its students' body some specified percentage of a particular group merely because of its race or ethnic origin. The court recognizes that such an interest would amount to outright racial balancing, which is patently unconstitutional. The court concludes, however, that the law school's use of race in admissions is consistent with Justice Powell's opinion in Bakke, which only pays some attention to numbers.
In addition, it's important to note that in this specific case, the respondent is favoring diversity on college campuses rather than a specific race. And so yes, I believe that racial preferences, that the court should allow racial preferences to go on forever, but understand that those racial preferences and that race-conscious affirmative action may impact different races differently than it currently does. This is because, again, like my co-counsel has stated, the intention of race-conscious affirmative action is not to benefit one race over the other, but rather to create a racially diverse college campus, whether that means considering race in terms of Black Americans or white Americans. Just in order to build a more racially diverse college campus, race-conscious affirmative action is necessary and will continue to have a compelling state interest in the future.
Should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent discussion of stare decisis in Dobbs v. Jackson Women's Health Organization.
No, Grutter v. Bollinger should not be overruled. And in the Supreme Court's recent discussion of stare decisis in Dobbs v. Jackson Women's Health Organization, it was discussed the impacts of overturning Roe v. Wade, which happened in the Dobbs case, was discussed. However, it's important to note that overturning Grutter v. Bollinger is going to have extraneous impacts on a variety of Supreme Court cases, laws, and policies across America, not just impacting college campuses, but essentially anything that requires an application that currently uses race as a consideration. Examples of this would include military recruitment, in which selections for military leadership are made with the consideration of race, federal contracting, which also considers race as one of its considerations when selecting applicants. Additionally, employment opportunities in which employers use race as not a determining factor, but a factor in the process. All of these things would be changed and subsequently would be overruled if Grutter would be overruled. And so while Roe v. Wade was ultimately overruled, it's important to note that Grutter v. Bollinger, if overruled, is going to have much more detrimental impacts than that we see in Roe.
Yeah. If the court declines to overrule Grutter, can the plaintiffs prevail?
No. Grutter secures a compelling state interest in a narrow tailoring, which means the UNC's policy is constitutional. UNC cites Grutter in their affirmative action policy.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
Yes, the military has written numerous amicus briefs on various race-conscious affirmative action Supreme Court cases, stating that if Grutter is overruled, there will be a difficulty within the military to recruit a diverse armed service. This has been cited by numerous military officials and members of the military or representatives of the military in numerous amicus curiae briefs on various race-conscious affirmative action cases. And so if the military is stating that there will be a difficulty in recruiting a diverse armed service, this is only further evidence that Grutter should not be overruled and that the court should side with the respondent. Thank you.
Thank you.